or international agreement shall be valid and effective unless concurred in by at least two-thirds of all the members of the Senate. Then, as now, the provision required no explanation. It's clear no treaty or international agreement is possible without the approval of at least 16 of our 24 senators. From a layman's point of view, it is the Senate concurrence in the ratification that gives validity to a treaty. Without the Senate concurrence, there is no treaty. And there would be no treaty to abrogate. That's how my layman's ability to discern the law tells me. However, no similar constitutional provision requires the same number of senators to concur if and when the President decides to abrogate a treaty or an international agreement. Therefore, the presumption is that the President can abrogate a treaty or an international agreement all by himself without the concurrence of the Senate. The Constitution is silent on this. Whether this was a plain oversight or a deliberate act on the part of the framers of the Constitution, we have a serious constitutional lacuna, as the Dean referred to earlier, constitutional lapse, which we must correct. We have to ask ourselves, was the omission deliberate? And if so, why? Is it possible to speculate that, according to international practice, treaties are not lightly entered into, nor lightly abrogated? So it probably did not become necessary for the framers to put in that necessary provision. But the surest way to correct this is to amend the Constitution. Now, we don't have the time for that. We don't have the luxury of time for that. The best we can do now is to ask the Supreme Court to help cure this constitutional defect. I'd like to believe that a court which was able to remove an impeachable Chief Justice without going through the impeachment process can easily provide the doctrine which the framers of our Constitution failed to put into the existing text of our fundamental law. Some have argued that the decision to abrogate the VFA is a political act and not subject to judicial review. Indeed, as no court can question the President's decision to enter into a treaty, no court can question the President's decision to abrogate one also. And that we are not prepared to do. But since he cannot have a valid treaty without Senate concurrence, he should not be able to abrogate a treaty without Senate concurrence. I think that is quite clear. The decision to abrogate is the political act which is not subject to judicial review. But the manner in which it is carried out must follow the sense of the Constitution and the rule of equity and fair play. I don't want to go to an expansive discussion of the Constitution. We don't have the time for that. and that is beyond my competence. But having said what I just said, I should like to commend the committee for its effort to take a deeper look into defense and security treaties with our most important ally in the world. I'm particularly eager to see that the abrogation of the BFA, if it's not interrupted, should lead to a new beginning in our historic relations with the United States, which has become the home of many Filipinos outside the Philippines, millions of Filipinos outside the Philippines. This would be in the best interest of both our two countries, of the whole of the Indo-Pacific, and the world. I'm sure this is one of the motivations behind these hearings, Mr. Chairman. With your consent, Mr. Chairman, I would like to say something beyond the purview of my being invited here. Now I believe is the opportune time for the Philippines and the United States to sit down together for a bilateral review of their overall relationship and determine the most desirable course for that relationship to take in this fast-changing environment. We should seize the moment. Who will make the first move? It's not for me to say. It's not easy to say. President Trump is facing an election, and President Duterte is saddled with so many critical issues beyond the reach of this committee. But perhaps a friendly third party like Japan's Prime Minister Abe can do a lot, can do a quiet job of trying to bring the two parties together. We need to take a broader look at our relations with the U.S. in order to go beyond the BFA question. The hearings in 1999, not 98, Mr. Secretary, 99. There was an expression of concern that the terms of the agreement were lopsided in favor of the U.S. The Senate, my colleagues at the time insisted that we balance. We remove whatever lopsidedness there was. So the decision resulted in the adoption of VFA-2, which would give Filipino armed servicemen same rights and privileges as their counterparts in the U.S. So it is not fair to say that we sold out. No. There are certainly provisions in the BFA that can be improved and should be improved, but the reality is that in negotiating treaties and concurring and the ratification, the hands of the Senate are tied up. We cannot alter one word in the basic agreement. We either concur or we reject. And this has happened in the new basis agreement which President Cory Aquino authorized to be negotiated by Raul Manglapos and Armitage after the expiration of the MBA. So this is the reality. But I think we owe Senate Minority Leader Drilon a vote of thanks for bringing this issue to the fore. The power of the President is granted, but it is not unlimited. It is not absolute. It must submit to the bounds of reason and good sense. We cannot question the patriotism of the president, but we can point out that this decision, based on the cancellation of the passport of a former colleague, Senator De La Rosa, is a serious mistake that cannot be inflicted on the history of our diplomacy or on the posterity of the Filipino people. Thank you very much, Mr. President.
Thank you, Senator Tatad. May we now hear from Senator Biazon.
Thank you, Mr. Chairman. The Philippine government served notice on February 11 this year the termination of the Visiting Forces Agreement. When I was sponsoring on the Senate floor as chairman of the Defense Committee, 1999, the Visiting Forces Agreement, for concurrence of the Senate, Admiral Blair, the commander of the Pacific Command, issued a statement in Singapore. And he said, these practices are not covered by the Mutual Defense Treaty. And so during the hearings, I raised the question to Ambassador Hubbard. I asked Mr. Ambassador, is this the position, is this the policy of the United States as regards to the conflict in the South China Sea? That indeed, Kalayaan, our small town, archipelagic town that belongs to Palawan, is not covered. But it's a town of the Philippines, not covered by the Mutual Defense Treaty. And so I said to Ambassador Hubbard, if this is the policy of the United States, I said, I am not going to vote for the VFA. And he said, I cannot answer it categorically. But after a few days, he came back and provided a copy of a note verbal to Secretary Siason. And if I may be allowed, so that we will better understand it, I will read it. Dear Mr. Secretary, says Admiral Hubbard, I was very distressed to see the headline in the May 24 edition of the Philippine Daily Inquirer regarding recent statements by the Commander-in-Chief of the U.S. Pacific Command, Admiral Dennis Blair. Although I have not seen the full text of the Admiral Blair's press conference, I am concerned that the United States policy has been seriously misconstrued by the Inquirer. As you can see, the body of the Inquirer article does not support the headline, U.S. Admiral, VFA, no security blanket. And he went further. The United States government stands by its statements in the Vance-Romulo letter of January 6, 1979, which covers our obligation under the Mutual Defense Treaty in the case of an attack against the metropolitan territory of the Philippines. As well as in the case of an attack on Philippine forces in the Pacific area. Last August, he said, in response to the questions on this issue during his visit to the Philippines, the United States considered the South China Sea to be part of the Pacific area. And so therefore, the concurrence to the proposed BFA at that time passed the Philippine Senate. Now, indeed, there is not now a review for a lot of things. Number one, a review on the question, do we need the VFA? maybe we may have to go very shortly on the history of the agreement with the United States. The Philippines entered into a treaty with the United States in 1947 for the existence of the Military Bases Agreement and the Military Assistance Pact, the Mutual Defense Treaty. But in 1991, after the collapse of the USSR in 1989, we entered. There was a proposal from President Cory Aquino to approve a new treaty regarding the military bases. The Senate voted against a new treaty. Right now, the main issue being raised against the VFA is the issue of jurisdiction on criminal cases against U.S. personnel. Now, we have 171 days, probably, a chance to modify, because modify the VFA, because according to our Constitution, after the serving of the notice of termination, there still remains 180 days or 6 months for something to be done. So maybe when we consider these things, it still remains 100. We can take a look at the possibility of something to be done before the end of 180 days. We still have 171 days. Okay? Now, what can be done? Maybe consider a modified or amended visiting forces agreement, if the president, of course, will allow it. I'm not going to enter anymore on the shared power, and because it's publicly known, the shared power. Unfortunately, our Constitution is silent on the issue of termination of any treaty. It is silent. And that is the reason why there is a pending case before the Supreme Court on the issue of our withdrawal from the ICC. Hanggang ngayon, hindi pa yan. And that's the raising the question, can the President unilaterally terminate a treaty? That is now a case before Supreme Court. And the second one will be probably the issue of the visiting forces agreement. And I agree that the only way to resolve the question is through the Supreme Court. And so therefore, there will be a second case to be filed before the Supreme Court questioning the unilateral exercise of the power to terminate treaties. Pupunta ho yan sa Supreme Court. First, review. When this thing came out, I thought we need to review the reasons why we enter into in these treaties. For example, when I attended the hearings in The Hague, I was the only legislator who was present there. There were Japanese representatives, there were Vietnamese representative, there was an Australian representative, Indonesian, etc., etc. I asked them, why are you here? This is a case for the Philippines. And they said, well, we are interested in the resolution of the issue you raised before the court. And this is ano ba ang United Nations Convention of the Law Provisions, And so therefore, I said, they said, we are interested because if you win, we win. I mean, those other countries, no? And I said, well, if we win, we win. The issue of whether you also will win is subject to bilateral and multilateral considerations of the Philippine government and your governments. For example, the Chinese members of the Diet and diplomats came to me and they asked me about what is our position relative to the Sprat list. And I said, we have filed a case before the International Court, the Permanent Court of Arbitration in The Hague. And I said, but to challenge the aggressive acts of the Chinese, I said, we need to form a coalition of countries that are interested in the resolution of the problem in the disputed area, South China Sea. Because, and there are many countries that are interested in the resolution to the question. $6 trillion worth of trade and commerce passes through that channel, right? Japan is affected. Even Europe is affected. Of course, the Americas are affected, etc., etc. So I said, we have to form a coalition of nations to challenge the aggressive acts of the Chinese. No one country can do that, especially us, small nations. So, of course, I said, you have a problem. You, the Japanese, are the first to be affected by the acts of the Chinese. When the Chinese declared an defense zone, air defense zone over Senkaku Island, which is your property, I said, you already are affected. And will you address this alone? I said, have a problem with your constitution. Because your constitution does not provide for participation of the Japanese forces outside of a definite area. I said, so I asked, are you going to amend your constitution? He said, no, Mr. Senator, we will change our interpretation of our constitution. We will amend our interpretation of the constitution. 1 week after, Prime Minister Abe announced, we will change the interpretation of our constitution. We will not amend our constitution. Now the question is here. There was proposed kanina the possibility of amending our constitution to address the issue. But sabi nga ni Senator Tatad, matagal yan. And so the shortest way to do this is for people, institutions in the country, the Senate, going to Supreme Court for a final resolution of the issue on the question of can the President unilaterally abrogate a constitution. So I would join such an effort to raise the issue to the Supreme Court. Thank you, sir.
Thank you, Senator
Thank you,
Bias.
Mr. Chairman.
Drafted naman, petition. Okay. So just for the information of Senator Biason, the petition is currently being drafted. So can we now go to the next resource person, Professor Tayaw, and then Father Aquino, you're next. Can we be conscious of the time? Mga siguro 10 minutes. If your paper is longer, just submit the paper so that we can have a freewheeling discussion, questions from the senators. Thank you. Thank you.
Actually, Mr. Chair, each time I'm invited in the Senate, I usually consume only 3 minutes, 5 minutes max. Because, of course, I know that there are so many other resource persons who may probably shed light on the issue. I will follow through on the comments of our esteemed former senators and actually to me statesmen, now Senator Tatad and Senator Biazon. I'm honored to be seated beside them. My thoughts would be more on the political side and, of course, the policy side in terms of reviewing the policy that is the VFA. You know, while remaining an ally of any country, bear in mind that we become part of its circle. Their friends become our friends, and their enemies become our enemies. We'd like to look around and understand how, in this scheme of things, we figure ourselves into. And so I agree with the comment of our Dean earlier, mentioning that we'd like to compare ourselves or probably learn from how the other countries benefit from their relationship, their treaties with the US and other countries. And probably learn that it might be interesting to ask why our neighbors like Indonesia, Thailand, and even Vietnam gain more out of this relationship than the Philippines. However, the government that is the executive and the Senate decides how to move forward, I'd simply hope, as I suggest, that we start approaching decision making by way of systems and not just be limited with the relationship between the US and the Philippines. Ever since we've been doing much of our policy making and even governance piecemeal. This is also one of the reasons why we've been approaching constitutional reforms so many times and for decades already and have not done enough really to get into it. No? Mine is, of course, mainly political, but there are so many lawyers and experts of law who I'm sure understand that politics plays right into the heart of lawmaking and policy making. Note also that it reflects, note and reflect how we have voted on the US basis in 1991. I think this has been discussed extensively by Senators Tatad and Biazon, and how it resulted too in terms of politics, economy, and the community. Our foreign relations should also be understood as a tool of the nation, if not even in continuing pursuit of nationhood. So to my mind, however we proceed, whether, at the end of the day, we might also want to reflect on current events. However big and powerful a country is, in a snap, it can go down. Look at how things are going as far as COVID-19 is. No? We've been looking so high to China. I don't know whether in place of the US or not, but things are changing rather fast now, and we'd like to probably figure out how to move forward as a more independent and sovereign country, not only in name, but also in terms of policy. Yun lang, Mr. Chair.
Thank you, Professor Tayo. Father Aquino, please. Thank you, sir.
Good morning, Your Honors. I shall treat the issue before us as a matter of purely of constitutional theory, as the chair and as the panel wants it to be treated. One subject that I teach in the Graduate School of Law is legal hermeneutics. And one way of testing the plausibility of a proposition of law is to review its consequences. If we maintain the proposition that the president alone or the president has unilateral power to bring about the revocation of treaties or their denunciation, then the consequence is that he can unilaterally withdraw the Philippines from the United Nations or even from an integrated ASEAN, a consequence which would not only be disturbing but also absurd. The silence that Senator Tatad observes about the Philippine Constitution in respect to the revocation of treaties is understandable because we are, after all, heirs to the American Constitution, and the provenance of the treaty provisions of the Philippine Constitution is clearly American. And the American Constitution is likewise silent. And its silence is not because it intended to confer power on the president alone, Because for the first few years, in fact, for the first decades, if not centuries, of American history, cancellation of treaties was a congressional function rather than a presidential function. The first treaties to be declared null and void were declared null by Congress alone, the French-American treaties of 1778 to 1788. In 1846, when President Polk wished to revoke a treaty with Great Britain, he first served notice on Congress and requested permission from Congress to do so. In 1856, the Senate Foreign Relations Committee made the following statement very clearly. Where the right to terminate a treaty at discretion is reserved in the treaty itself, such discretion resides in the President and the Senate. The whole power to bind the government by treaty is vested in the President and Senate, two-thirds of the senators present concurring. The treaty in question was created by will of the treaty-making power, and it contained a reservation by which that will should be revoked or its exercise cease on a stipulated notice. It is thus the will of the treaty-making power which is the subject of revocation, and it follows that the revocation is incident to that will. The will resides in the President and the Senate. When President Lincoln in 1864 notified Great Britain of its intention to withdraw from the Rush-Bagot Convention, Congress immediately passed a joint resolution declaring Lincoln's conduct invalid until ratified or confirmed by Congress. On December 18, 1911, President Taft gave notice of his action to the Senate, informing Russia on the U.S. intention to terminate the commercial treaty with Russia. But this was only because the termination was at the instance of Congress. The Spanish position is bifurcated. The participation of the Cortes Generales is necessary in respect to those denunciations of treaties that affect the economy or the defense of the country. Thus, under Spanish constitutional law, military treaties, including the presence of foreign troops in Spain, are among the treaties that require the action of the Spanish Cortes, both for their entry into force as well as for their denunciation. Your Honors, I would like to point out the same thing that was pointed out by Dean Mel Santamaria, who is a dean in his own right, but is also one of the professors in the graduate school. So I'm also his dean. I hope he does not mind that. In the case of Democratic Alliance versus Minister of International Relations, tried by the High Court of South Africa, the court said, where a constitutional or statutory provision confers a power to do something, that provision necessarily confers the power to undo it as well. In the context of this case, the power to bind the country to the Rome Statute is expressly conferred on Parliament. It must therefore perforce be Parliament which has the power to decide whether an international agreement ceases to bind the country. This is the statement of the so-called mirror principle articulated by Senator Drilon. I would like to end with a quotation, Senator, Your Honors, from Alan Swan, who wrote on the Mutual Defense Treaty between the United States and Taiwan, which President Carter attempted to terminate. She says, if the Mutual Defense Treaty was both a source of domestic law and an international compact, and if, as the court concedes, only Congress can supersede a treaty as a rule of domestic law, then the President's ostensible power to terminate the Mutual Defense Treaty as an international compact is anomalous at best. In other words, because it is both a creation of Congress through the Senate and of the President cannot claim sole power to withdraw from that legal order. Prior to this hearing, Your Honor, I have compiled a series of studies on treaty termination and revocation, and if Senator Pimentel wishes, I can submit it to the committee.
Please, we are very much interested, Father Aquino. Comsec. Father Aquino will submit. Very much, Father. Is that your presentation, Father? You're done?
And my presentation ahead of time, these are some materials I used here.
Can I ask you one question? What happened to the U.S.-Taiwan Mutual Defense Treaty? Is it in fact already terminated?
Well, that's a very interesting question, Your Honor, because up to now, the standoff has not been resolved between the United States. And that is why the Supreme Court of the United States, as already mentioned, has no definitive statement on that yet.
Okay, so we opened the floor to discussions from senators who may want to ask questions, direct or make a statement or direct questions to our resource persons. Senator Gordon.
Yes, thank you all very much, and good morning to all the resource persons. It's admirable that we can talk here and discuss the pros and cons, although there is only one pro, and I understand why that is so. Let me just ask a question. Right now, our parliamentary situation, if I may call it that, nandito tayo sa sitwasyon na we have to, I'll speak in Tagalog so people can understand outside. Dahil yung proseso natin ay nalalagay sa alanganin. Sabi nga nila, kung makaka-enter ka ng isang agreement, pwede ka rin lumabas, lalo na shared power yung pag-enter into an agreement. Malinaw yan. At sinabi ng Constitution, kailangan 2/3 vote at Senado ang mag-ratify. So sa akin, yung sinabi nila lahat, halos, especially Dean Santa Maria, Father, and of course, Senator Tadad, and Senator Biazon by force of one, and of course, Mr. Tayo, it really indicates that before we can even go into that, and I don't even want to go into the terms of the VFA, wala pa tayo doon, yung proseso muna, makakapasok ba tayo na ang Senado kung hindi natin haharangin muna at sabihin, we don't agree that you can unilaterally withdraw from the agreement without the Senate. In other words, kailangan we have to create a position of na we're opposing the move of the President to do so without Senate approval. And that way, we can now bring it to the Constitution, to the Supreme Court to address a constitutional issue na nagbabakbakan na itong dalawa, Senate at saka the President, the Office of the President. Would that be correct? I'd like to address that to Dean Santa Maria first.
Basta't nagbabanggaan na po talaga ang Kongreso at ang ehekutibo sa isang fundamental na issue at halang na halang ang kanilang posisyon, talaga magkakaroon ng constitutional issue. Sapagkat kung mag-decide ang Korte Suprema one way or the other, siguradong yung isa magkakaroon ng sentimiento na nabawasan ako, I was diminished. And he will just proceed with that diminished situation, hoping na siguro through constitutional amendments or legislation, mababago. But at the same time, parang may nabasag na sa isang napaka-fundamental na prerogative ng akala ng isa'y nasa kanya.
Sir, from my standpoint, the Senate has a duty as a co-equal branch of government, as part of the Congress, and especially since directly assigned sa kanila yung ratification of treaties. So if we do not speak, our voices will be absent in this process where from the very beginning we were part of. As you said, when you declare war, the President has to go to the Senate, to the Congress, both houses. No? Lahat yan, kasama yan. The veto power, as you said, process yan. So when you start, if we keep quiet on this issue, we would be reneging on our constitutional duty as stated in Article 21, Section 7, is that if I'm correct, no? Na if we can ratify, we can also refuse the abrogation or reject the abrogation. But first, we have to create some form, and I don't want to use the word casus belli for lack of a better word, a casus belli, a misunderstanding, a constitutional misunderstanding has occurred, and that's how the Supreme Court can come in. Would that be correct, sir?
Meron pa akong puntong isa. kahit na kung papaano pong magdesisyon ng Korte Suprema, I'm always of the position na Supreme Court decisions must, well, although final, must always be subject to debate.
And scrutiny. And scrutiny.
Scrutiny, subject to scrutiny and debate, para na nga hindi mamatay sapagkat may iba pang branches ng government na maaaring i-overturn ang Supreme Court. Yan po nakakalimutan natin eh. Supreme Court decisions may be final, but they are always subject to critical debate and
Which is
scrutiny.
the point of Senator Biason earlier. Nagkaroon muna tayo ng mutual na military bases, na nag-iba ang panahon, nagkaroon tayo ng Mutual Defense Pact because pumasok na nga yung tatawag nating China was taken over by Mao. So it was so proximate to us, so pumayag tayo na magkaroon ng Mutual Defense Pact. I kind of like what Senator Tata referred to earlier on another part of the process. Can the Senate now look into the manner upon which, as Senator Tata said, yung manner ng pag-abrogate? You know, we do have, we should have a sense of national pride and integrity. When a president, for an example, says, I'm abrogating because my man has been denied a visa, or for that matter, parts of the membership of the Senate of the United States says, mali yung ginagawa nyo kay Leila de Lima, which prompted me to say, you're intervening in our affairs. If you want to intervene, send a lawyer to Secretary de Lima because our courts are functioning. Sa akin, any statement made by a senator not formally approved as a law is fair game. So, yung manner na napaka-frivolous or whim or caprice, ang dating sa akin ganun eh. And it really, attacks my feelings na hindi natin dapat payagan naman na ganun ang gagawin ng ating Pangulo na just because hindi nabigyan ng visa isang kaalyado niya, yun ang maging rason. And I wonder how the DFA feels about it. Was that the real reason why we're abrogating? Don't we look into that? Or is there any advice given na we made China happy, we made America sad because of this? I don't think it really applies to and we would have to go through the circumstances of need now, just as we needed the Mutual Defense Pact when China became superior when Mao Zedong became superior in China. Ngayon, ang sistema natin ngayon meron tayong mga disagreements with our Chinese neighbors. They don't even follow the arbitral ruling. They ram our ships, they ram our boats, and leave us there in the ocean, and they just take over islands. So, to my mind, ang problema natin dapat siyasatin natin maigi kung ano talaga ang rason. Hindi naman yung ganong kababaw o ganong kasidhi. And I'm, of course, talagang ganyan we have to, that is our role. What do the DFA say about that? Is that the real reason for it? O i-abrogate natin ang DFA, hindi yung VFA.
To the chair, I hope not, Senator Gordon. Well, thanks for the question. The DFA, we don't think that we could read beyond what the President has pronounced on as to the reasons for...
You don't think you can advise the President?
We definitely have advised the President.
And what was your advice?
Secretary Locsin met with the President, I think, and Ambassador Babes Romualdez was here to make the case, but the President had already made up his mind, and it's a decision, of course, that we're bound to pursue.
And then, with the permission of the chair, I go back to the theory of absolutism espoused by Dean Santa Maria. Non-absolutism. Yeah, I'm sorry. Well, whatever. The point is, the whole foundation of our Constitution is against unilateral exercise of power, absolute power in one side of government or in one man. And therefore, the whole design of the Constitution is checks and balances. Dahil hindi ka naman pwedeng basta gagawin mo yan wala na, di ba? So, I'm happy that you cited some cases in South Africa when they tried to get out from the ICC, right? And the other case that you cited was UK. And what was the issue in the UK? ICC also? European Union. Brexit. Brexit, yeah, Brexit. Tama yan, tama yan. So it has to go through Parliament. Yeah.
Yes,
Answer
yes.
into the mic, sir, Dean.
Yes, they had to go to Parliament to get the consent of Parliament.
And because of this theory of separation of powers, yung tatlong arm will work together. Kung
Yes.
hindi umayag ang Senado sa abrogation, now the Supreme Court gets involved, so it shows the balance of and control of powers. Now it cannot be lodged in one side of the government or one man. Would that be correct, sir?
That's correct, Your Honor. And as a matter of fact, in the U.S. case of Goldwater versus Carter, up to the Court of Appeals, that was the point.
The point of Justice Powell there, and I keep quoting this, was that Powell, while agreeing that the case did not merit judicial review at the time, believed that the issue itself, the powers of the president to break treaties without congressional approval, would have been arguable had Congress issued a formal opposition through a resolution to the termination of the treaty. In other words, kailangan mag-issue kami ng formal opposition, in resolution. That's why I laud Senator Dillon, because he was quick on the draw, not recklessly, but to protect the prerogatives of the Senate.
Yes.
I would not want to see the Senate become saling pusa, in other words, sa Tagalog, no? Because that's the protection of the people.
That's correct.
That if a president runs amok, or the Senate runs, or Congress runs amok, the president can always veto the Senate or veto Congress, and vice versa.
That's
The Congress can also override the veto, or for that matter, protest on the abrogation of the agreement. That is all, Your Honor. Thank you very
Senator
much.
Dillon wants to ask a question.
Mr. Chairman, I want to refocus on the item in the agenda, and that is proposed Senate Resolution 305, where we are asserting the sense of the Senate that our consent is needed before a treaty can be validly abrogated. So this is that is where the issue is, and that is why in the at least 20 ratifications or concurrence with the ratification, the Senate inserted a clause that the termination of such treaty should carry the concurrence of 2/3 of the Senate also. And that is found initially in the climate change treaty, Paris Agreement, and subsequently in the agreement establishing the Asian Infrastructure Bank, etc., etc. There were 20, and I have not heard any comment from the DFA on this 20. And this is now part of the ratification process that we went through. And maybe I want to hear Father Aquino, Dean of the San Beda College of Law, on this point, on the process.
Yes, Your Honor. The basic requirement for bringing a case to the Supreme Court like this is that an actual controversy should exist. So I do strongly suggest and advance the proposition that the Senate send a resolution to Malacanang expressing its sense that the President alone does not have the prerogative to withdraw from the treaty, and that the Senate's concurrence should first be obtained. And if Malacanang disregards, it's then that an actual controversy exists, and then the matter will be ripe for the Supreme Court to decide. With all due respect, Your Honor, not through declaratory relief, because the Supreme Court has no jurisdiction over declaratory relief, but through one of the prerogative writs, Your Honor.
Yes, we are aware of that rule, but this is, we can argue that this is a transcendental issue which should merit the attention of the Supreme Court, even if technically
Yes,
it
Your
should
Honor.
be with
Conceded,
the,
Your Honor.
yeah, with the lower court. So, we will address the Supreme Court in a petition for declaratory relief to define the constitutional boundaries between the Senate and the executive insofar as withdrawal from treaties are concerned. Because there are a lot of implications on the withdrawal, a unilateral withdrawal, ignoring the Senate.
My only proposal, Your Honor, is that preceding the action, or maybe concurrent with the action, would be a resolution by the Senate sending its sense to Malacanang that it should be it should be sought, its concurrence should be sought in the withdrawal.
Yes, we can also do that, but also the sense of the Senate will, if adopted by the committee and the plenary, will bring to the Supreme Court the position of the Senate. And we are, since the Supreme Court is the final arbiter on issues on the Constitution, then we are just asking that please, Mr. Supreme Court, define our prerogatives, where is the boundary? That's all that we're saying. Of course, inevitably, in this discussion, the focus on the VFA is understandable, but really it's beyond the VFA. It is the issue of the authority of the Senate, especially, Sec. Bailen, that the ratification, the concurrence in the ratification that the Senate did was contained a very specific process for the withdrawal, and that is the concurrence of the Senate. So that is this, not because of whim or caprice, but because there are policy issues. We repeat, when we withdraw from the ASEAN multilateral agreement, what are the implications? When if we sustain that the president has the sole authority, can he withdraw from the UN? Can he withdraw from the UNCLOS? The consequences of this withdrawal affects many policies and domestic laws, which should prompt and the participation of the Senate and the Congress, because the Congress is the policy-making body in our government. So it is in that regard that I would wish the committee to refocus. What is before us is a sense of the Senate resolution.
Thank you, Senator. Senator Tatad wants to react, yes.
We appreciate the remarks of Senator Drilon, and I'd like to state that it's for that reason that I tried to make a very focused presentation on this issue. I think the only issue, as far as I can see it, is that no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. So the BFA is a valid treaty because it was concurred in by, how many were we, Pong? 2/3 of the members of the Senate. So it is the concurrence in the ratification of any treaty that makes that treaty valid according to this constitutional provision. If you want to invalidate it, you are invalidating the concurrence of the Senate. And the executive cannot do that without consulting with or with obtaining the consent of the Senate. That is my very simple proposition. I only regret, I hope Sir Biason here joins me in this regret, that we are unable to join the authorship of the Drilon resolution. We are no longer active members of the Senate, but we would be honored to join the petition before the Supreme Court at the proper time.
Again,
Thank you.
Senator Tatad, the petition, the intended petition in the Supreme Court is a petition for declaratory relief, which Father Aquino was also the same remedy availed of in the Goldwater case. The Goldwater case also used the route of a declaratory relief to define the functions or the powers of the Senate vis-a-vis withdrawal from treaties. So that relief has been availed of. And that is what I would like to strongly suggest to Senator Soto, who is leading the effort there. But what we would like to see is an adoption by the Senate in plenary of a position that we should be consulted in general, without any reference to any particular committee, particular treaty.
Thank you very much, Mr. President.
Yeah.
Senator Biason,
Thank you, Mr. Chairman.
after the Senator Binay, after.
Reading the Senate resolution, proposed Senate resolution number 305, this is seeking approval from members of the Senate in the expression. But if this passes, the Senate, will it compel anybody to abide by it? No.
No, it will not.
Will not.
But
It
let
will
me
not.
finish. It will not, because it will not compel, but it brings us to the Supreme Court.
Exactly.
And let the Supreme Court decide
exactly.
on the
Yes.
constitutional boundaries. But insofar as the Senate is concerned, which is a co-equal branch, we
That's
say
right.
this is our position.
That's right. But it will not, a passage of this resolution by the Senate will not compel the President. So we still have to go to the Supreme Court. And we need a
But-
final ruling.
By the way, Senator Biason, as we said, in 20 of those treaties, we inserted a whereas clause,
Yes.
which basically says you cannot withdraw from this treaty
Exactly.
unless there is a concurrence of 2/3 of the Senate. That is expressed there. And that has been there for the last, I don't know how many years.
But that is not contained in the VFA.
No, because
is
it was
not.
passed in 1999.
that is
but
correct.
the sense of the Senate will now set the general rule.
That is correct. Now, is this not going to raise a constitutional question on the validity of that provision put in the new treaties? Is this not going to be questioned too? Yes.
This particular petition, which Senate President is planning to file, it's really
Exactly.
focused on the VFA. That's why we can expect the argument that in the Senate concurring resolution on the VFA, there is no such provision that
Yes.
Senate concurrence
Mr.
is needed.
Chairman.
That would be answered.
Mr. Chairman, the petition for declaratory relief does not necessarily and is not focused on the VFA. It is on the power of the Senate. It is a definition of
Subsequent agreement.
boundaries, not on the VFA. It is on all treaties and a definition of the powers of the President and the Senate, not the VFA only. VFA is only incidental because it demonstrates the interplay of the powers. But what we are asking the Supreme Court to rule is define for us as a political body what is our role in abrogation, and we are saying that the sense of the Senate is that we should have a role, and that this role is manifested in that provision in 20 of those treaties where we place the consent necessary.
Okay, so best not to comment yet on the petition until and unless we see it, the copy. Let me make of record the presence of Attorney Roque. Senator Gordo, Senator Binay muna. Senator Binay wants to ask a question. Senator Binay.
Thank you, Mr. Chair. Kay Father Aquino, ho, when you were discussing the 1987 Constitution, was there a discussion to include a provision that when we withdraw from a treaty, there's a need for a concurrence from the Senate?
Are you referring to the committee that was created,
Yes.
Your Honor, to study?
During the course of the discussion.
Yes, that topic did come out, and the journals of the committee will reveal that the sense of the committee at that time was the understanding that Senate concurrence was necessary for withdrawal.
And there was no need to write it,
Uh,
that provision.
We were very wary about putting it in at that time, Senator, because that was the time that the ICC issue was very much discussed, and we were afraid that we would be sending a signal, as the case had already been filed before the Supreme Court, that we were taking sides at the time. So we let it remain on the records that that was our sense, that it was our understanding as a committee that Senate concurrence was necessary for withdrawal.
Thank you.
Can
Mr.
we have that record, Mr. Father?
Senator, I suggest that you address it to Chief Justice Puno, who was our chairman, and who controls the secretariat for that. Yes, the journals of the
Of this latest one?
yes,
of this
Senator, the
Constitutional Commission,
the
yeah.
19th committee. Yes, po.
No. Puno eh. Father Aquino is mentioning Puno. So,
Puno,
Puno,
the committee
constituted
by President Duterte
to
to start the
review,
planning
yes,
areas,
yes. But as a, ito question ko sa'yo, Father Aquino, as a member of the 1987,
No, I was not a member, Your Honor.
you were not.
I,
Okay, so,
I was
okay,
only
so
in high
we-
school.
So it's the review, yeah. It's the Duterte, President
May,
Duterte's commission to review the 19.
Maybe we can request
But-
the chairman.
But I was saying, Your Honor, at that time, it was already the sense of the committee that it was our understanding that Senate with concurrence was necessary for withdrawal.
So can we just request that portion be the transcript? be made
Transcript,
part
yes, of
record?
the, we will ask from the Constitutional Commission convened by President Duterte to review the 1987 Constitution.